We start?
Yes.
Everyone stop talking? Good. That worked. I hope everyone's doing well. We are moving along, chugging along. The good news is we only have 2 topics left for future interests. The bad news is the hardest of the entire topic, but we are almost through this unit. Are there any questions? Anything on your mind from last week with vested remainders, with contingent remainders, with vested remainders subject to open? Anything on your minds? Yes, sir.
Okay, so just in debating, can you just explain the ascertained versus unascertained person?
Sure. I'd be happy to. All right, so I'll start with you, Carl. So when we're identifying different kinds of remainders, the first thing we look for is the future interest following a life estate? If the future interest is following a life estate, in 99% of the cases, it will be a remainder. Okay? Not always, but 99% good enough for you. To determine if it's a vested remainder or if it's a contingent remainder, we ask ourselves 2 questions. First, is the beneficiary ascertained? All ascertained means is identified or named. If it's a person who is named, if you call him B, if you call him C, if you call him Johnny, he's ascertained. If it's something vague like the children of B or the heirs of B, that may not be ascertained because we don't know who those people are yet. So all ascertained means is a person is known. We know who the person is. And if there's a name of the person in the question, then that person's ascertained.
So if at the end it says to be in his heirs, and then it says his heirs are X and Y, his heirs are ascertained?
If the person is named, they're ascertained. If there's a name there, X, Y, B, C, whatever, that person's ascertained 100% of the time. Is that your question? Yeah.
If you name a class like these children,
Children,
that's still ascertained.
so that is what's called the vested remainder subject to open. Okay. So say, right, you say the children of B, and at the time B has 1 child. He may get brothers and sisters at a later date. So you would say that B has his vested remainder subject to open. What if B has no children? Right? What if B has no children at the time the instrument is drafted? The children of B have contingent remainder. Why? B may die without kids. So you have to look at the time the instrument is drafted. Are there any kids? If there's 1 child, it's a vested remainder that's subject to open. If there are no children, then the class, right? The class has a contingent remainder. You don't know who those kids will be. There may be no kids at all.
That was basically my question.
Yes, got it. Good. I try. All right, so let's do a little bit of reviewing to start, and it more or less repeats what I just said. So when we're discussing future interests, the question we ask ourselves is the future interest in the grantor, or is the future interest in a third party, or a transferor? So we've discussed 3 kinds of future interests in the transferor. And that means third party. I'm not spelling well today, I'm sorry. Transferor. Okay. We discussed the reversion, right? We've discussed the possibility of reverter. And we discussed the right of entry. I'm sorry. This is the grantor, my mistake. So the future interest in the transfer of the grantor, we've discussed 3 kinds. A reversion, a possibility reverter, and the right of entry. You need to remember which present interest these match up with. So the possibility reverter follows a fee simple determinable. The right of entry follows a fee simple subject to conditions subsequent. And to finish it off, the reversion can follow life estate. Okay. You need to know this backwards and forwards. We've also discussed the future interest in the third party. Which is called the transferee. It's really just a third party. And we've discussed 3 kinds of these. Okay. We have the vested remainder. We have the contingent remainder. And we have the new thing today, the executory interest. So when you see that the future interest belongs to a third party, you need to ask yourself, is it going to be remainder? And if so, what kind will it be? Or will it be an executory interest? We'll discuss that later today. So by way of review, in order for a remainder to be vested, it follows a life estate, and the person is ascertained, and it's not subject to condition precedent. Right? These are the 3 things you have to look for. If it's following a life estate and it goes to a third person, and the person's ascertained, and it's not subject to condition precedent, that tells you that the person has a vested remainder. And we discussed a species of this, which is a vested remainder subject to open. The vested remainder is subject to open. This is what George asked me about a minute ago. This is a situation where the grant says to the children of B, B has 1 child. So if a certain, B's remainder is vested. But he may end up having to share that with his brothers and sisters. Therefore, his remainder is subject to open. Other people can join the class. Okay. The second type of remainder we discussed is a contingent remainder. Here, it's not ascertained, or it's subject to condition precedent. If either one is true, then the remainder is contingent. Okay. So you know these are the 2 different future interests following a life estate. The biggest difference, and this is moving on to what we're covering today, between the contingent and vested remainder and the executory interest is that the executory interest does not follow a life estate. Okay? It does not follow a life estate. It follows a defeasible estate. Okay? The executory interests, they're not following a natural termination of death. The executory interest is following something that precedes death, that cuts short an interest during life. And as we'll discuss at length in class today, these new interests emerged. They arose because the feudal lords tried to cut short an interest during life. They didn't want to wait until the life estate ended. They want to cut it short earlier. Okay. Any questions on that? This is, if you notice, I'm not using the chart anymore. And the reason why is because at this point the chart becomes unhelpful because there's so many different exceptions. The chart helped you up until class last week. It's not helpful anymore. Now I'm onto lists. But these future interests in a third party, you need to be able to distinguish. Okay. You now have a total of 6 future interests that we've discussed. You're going to need to be fluent in reading any of these and deciding which one is at stake. Any questions on the general gist of this list that I just put up on the board? Stop me if you have any questions. There's a lot moving in this class. Yes, sir.
I think you mentioned on executory interest, doesn't follow that state, whereas death is natural, so it falls in the natural death.
Yes, yes. And if you notice, I said a defeasible estate. I didn't say fee simple determinable or fee simple subject to subsequent. This is the broad umbrella of estates that are not terminating upon death. Something else happens at which the interest is cut short. So I just said defeasible. I didn't say what kind. Make note. Don't confuse defeasible with fee simple determinable. They're not the same thing. Defeasible is a broad umbrella. Speaking of the rain outside, it's the umbrella. I didn't bring an umbrella today. I'm going to get wet later. Okay. I just remembered. Okay. Any other questions before we move? Okay. So the entire idea, okay, the entire idea of the executory interest is about cutting short some sort of interest during the life. It's about cutting short some sort of interest during life. And there are two types of executory interest. Actually, you know what? Let me come back to that. Actually, let me do the other things first. I like example number 7 first. I'll come back to the executory interest in a minute. On second thought. So please open your book to example number 7 on page 283. I called an audible, I suppose. Omaha. Okay. Where was I last week? I don't remember. Thank you, JL. You want to please read example number 7?
Conveyed to A for life, then to B and her heirs, if B survives A. And if B does not survive A, to C and his heirs.
Whoa, right. That one's crazy. Okay. Let's walk through this one at a time, JL. And the way I want you to do this is by reading comma to comma. The commas are very deliberately placed. These are your guide. These are your guideposts. So JL, let's just start. To A for life, what is A's estate there? Beautiful, perfect, okay. Then it says, then to B and her heirs, if B survives A, okay. What do we call the remainder? Damn it. What do we call the future interest in a third party afterlife estate?
Is it a vested remainder?
Oh yeah, so let's start with remainder, right? Now, it's a remainder because it's in a third party after a life estate. I just all the time I give away the answer. I'm sorry, but now, JL, here comes the tricky part. What kind of remainder is it? Ask yourself these two questions. Okay, is the third party ascertained? Is he named? Okay, B, right? B is ascertained. Is there a condition precedent?
No,
Why is it subsequent?
because it's not a natural death. Because they have to outlive.
So that's a condition precedent, isn't it? Right? You said it correctly, right? B has to outlive A. Before B gets it, a condition must take place. So what kind of condition is it? I don't know, you said it. The condition happens before. B has to outlive A. Before B gets it, B must still be alive. The condition comes before. So JL, what kind of remainder is it? If there's a condition precedent. Yes. Okay. It's a contingent remainder. The reason why is there's a condition precedent. So B has a contingent remainder. It's not vested, right? Ask yourself those two questions. It's not vested. There is a condition precedent before B gets it. Pay very careful attention to the conditions. Okay. So let's see. I was going that way. All right, Daniel. Let's talk about C now. How would we characterize C's interest there? Ask yourself the two questions. It says, comma, and if B does not survive A, to C and his heirs. Is C ascertained? Is the person C known? Yes, C is known. Is there a condition precedent before C gets it? Does something have to happen before C gets it? Yes. There is a condition precedent there. It says, if B does not survive A, That is a condition precedent that happens beforehand. Therefore, if it's ascertained and there's a condition precedent, what kind of remainder is it? Yes, sir. This is what you need to be able to do. I know that's difficult, right? But you need to look very carefully. Is there a condition happening before the person who's ascertained gets it? If the answer is yes, therefore it's a condition precedent. And once it's a condition precedent, you know it's a contingent remainder. Everyone see that? Here we have two separate contingent remainders. We have a life estate in A, followed by a contingent remainder in B, followed by a contingent remainder in C. The book gives this tip later, and this is pretty good. If you start with a life estate and you have one contingent remainder, and there's a remainder following it, it will also be contingent. In almost every single case that you find where you start with the life estate and you have one contingent remainder, there will then be a second contingent remainder following it. That will be your way of checking it. You should always do it yourself. Make sure you ask yourself those two questions. But if you find that you have a life estate followed by two contingent remainders, you are probably correct, more likely than not. Everyone okay with me so far? All right, Cesar, can you please read number 8?
O conveys A for life, then to B and her heirs, but if B does not survive A to C his heirs.
Okay, thank you, sir. Let's read this one, please, comma by comma. So Cesar, A for life, what is A's interest? Very good. Now it says, then to B and her heirs.
Vested remainder.
Why is it a vested remainder?
B is ascertained as a condition.
Exactly, okay? Ignore all the stuff that comes after it. Cesar did the exact right thing. He stopped the comma. There's all the stuff that comes afterwards, that but if B does not survey, blah, blah, blah. Ignore it. Read comma to comma. So A is life estate. B has a vested remainder in fee simple. That's exactly right. Okay? Josh, now we go to the next clause. But if B does not survive A to C and his heirs. Okay? So where is the future interest? Is it going to the grantor or going to a third party?
I'm sorry, I'm also taking notes. Where are we?
So example 8. Okay, so we said A has a life estate. Cesar was correct. B has a vested remainder because there's no condition precedent. Then we get to, it says, but if B does not survive A to C and his heirs. How do we characterize C's interest?
C has a contingent remainder as well.
Why is, well, not as well, there's no contingent remainder yet. Why would you think it's contingent remainder?
Because it's relying on B not surviving A.
But look what it says. But if B does not survive A to C and his heirs, okay? I want you to compare very closely 7 and 8. I can't get them on the screen at the same time, right? Okay. In 7, A has it for life. Okay. A has it for life, Josh, right?
Yeah.
But what happens if B does not survive A? Just in English, right? We're not talking, fancy words. If B dies first, what happens to Blackacre?
A returns, Blackacre returns to A.
No. A dies, right? And B's already dead. What happens? What happens to Blackacre? Okay, good, right? There's no gap, if you will. The moment A dies, Blackacre's taken care of. Blackacre goes on to C. There's no gap of what happens, okay? I want you now to look at number 8 very closely. It says A for life, okay? Then to B and her heirs, okay? that is what kind of remainder? Vested, right? Okay. But if C does not survive A, I'm sorry, but if B does not survive A, to C and her heirs. Josh, how do we read that kind of future interest? Think about this. Let me ask a question like this. It's a very subtle point, right? Under this grant, what happens if B dies right away? Yeah. Who has the interest at that point? Who, at the moment B dies, who gets the interest? No. The moment B dies, what happens to the interest of B's heirs? Let me ask a question like that. And where does it go? Property must go somewhere.
If B dies before A.
Yes. That instant, what happens to the interest of B's heirs? It dissipates, but where does it go?
C.
Yes. This is the key distinction. Let me walk through this very carefully. Okay, pay close attention to this. When you're dealing with these contingent remainders, you don't ascertain, I'm sorry, portions of words. When you're dealing with these, I'll get you in a second. When you're dealing with the contingent remainders, you don't worry about C until A dies. Only upon A's death do you determine whether B's still alive. Let me say that again. With this example number 7, only upon A death do you determine whether B is still alive. Okay? Okay. However, in number 8, you don't wait for A to die. The moment B dies, C's interest executes B. When you use like execute like to kill, right? That's literally what it means. C's interest execute B's. It cuts short the interest of B's heirs. Nothing's hanging in the air. The second B dies before A, C's interest executes or cuts short B's. Okay. Therefore, what C has is not a remainder. It's not hanging out, waiting until there's a natural death. It cuts short during life. We call C's interest an executory interest because it cuts short B's during B's, it cuts short B's immediately before A dies. I realize it's a very a tricky concept, but let me say this one more time. With number 7, we're dealing with 2 contingent remainders. And we've said since the outset, a remainder floats around and waits for a natural death, right? It waits for A to die, and then it figures everything out. Like, you know, you can figure it out the moment A dies. In example number 8, nothing's floating, okay? Nothing's floating. B has a vested remainder, no doubt, but C's interest will cut it short. C's interest will execute it, you know, literally cut off its head, right? During A's life. So that way, once A dies, it goes right to C. There's no question. And the reason why will be discussed later. But to give you a preview, the common law did not like contingent remainders. It did not like contingent remainders. Why? Because they're always sort of floating around, right? Waiting. You didn't quite know if it'd be here or there. The law liked vested remainders. So for hundreds of years, the courts would actually destroy contingent remainders. They would destroy them. So it was much more preferable to have a vested remainder subject to being cut off than having these contingent remainders floating around. So examples 7 and 8, and I want you to go home after this and read those very carefully. Examples 7 and 8 really clarify the differences between the 2 contingent remainders and the vested remainder followed by an executory interest. They really clarify it. And there's actually a note on the following page, which you should read later. If you haven't, you should have already read it, but read it again. That goes through this. Yeah, Pierce.
Would we need to try and determine if these heirs have a contingent remainder? Because their future interest is contingent on these living.
If I asked you, okay, so are you talking about example 7 or 8? Okay. If I asked you what is the interest of B's heirs, yes, that's right. But I only asked you what the interest of B is. To that point, in an exam question, I will tell you whose interest I'm concerned about. Okay. In this sort of question, I'm not going to ask you what the heirs of B. I will simply ask you what's B's interest. Yes, sir.
Is it fair to say that the executory interest cut short A's life estate?
Well, it doesn't cut short A's life estate. It cuts short B's future interest. Be very careful. What the executory interest cuts short is B's future interest. It cuts short B's vested remainder. Because the moment B dies, to Pierce's question, B's heirs otherwise would have had something, right, coming to them. But the executory interest cuts that short.
I guess because
Ask again, to make sure what's actually happening. A is a life estate, right? That can't be terminated early. That's for his life. The second B dies before A, C jumps in there like a jerk, right? Pierce v. Post style. He jumps in there and cuts short B's future interest, right? B's dead, so he's gone. His heirs would have otherwise gotten it, but the C steps in there to stop it from transferring to his heirs.
I guess something like A's present interest.
No, A's present interest. A has it till he dies, no matter what. It's only when A dies that then goes to C. But what C is doing is cutting short B and his heirs. That's what they're doing. Yes, Cesar.
This might be a really dumb question. So if A dies, B is still alive, then it goes to B.
B gets it. Yeah, that's fine. B1, right? And that's why it's still a vested remainder. It's a vested remainder because if A dies and B's still alive, B gets it, and then C's out of the picture.
C never comes into it.
That's why we say that B has a vested remainder subject to an executory interest, right? Write that down, right? B has a vested remainder subject to an executory interest. It's vested, right? It satisfies our two questions, but it can be cut short. Students love saying, oh, that means it's contingent because it can be cut short. No. Very carefully. In virtually every case, not every, but virtually every case, when there's a vested remainder, it will be followed by an executory interest. When the first interest after life estate is vested remainder, the third will be an executory interest. Right? Let me write this out for you. These are called pairings, which help you somewhat, but not really. Okay, they're these pairings the book discusses. So you start with a life estate. The first future interest is contingent remainder. The third will be contingent remainder. If you start with the life estate and the first interest is a vested remainder, third interest, it will be an executory interest. This is not always the case, but it's damn near close enough. It's good enough for you. Like it's for your purposes. This will guide you most of the way. But use this only for checking yourself. Try to work it through, but this is like your check. Yeah.
So you would have two interests. You would have one, you have two times the vested remainder.
In example 8, what B has is a vested remainder subject to an executory interest. That's one thing. Right?
I thought he also had vested remainder.
He has a vested remainder and fee simple subject to an executory interest. Right? And the reason, I'll get you in a second, the reason why you know it's executory interest is you read past the comma. So it's vested remainder, comma, subject to an executory interest. You have to read each clause separately.
That's synonymous with subject to divestment?
Yes, yes. The book uses this phrase subject to that divestment and never uses it again. They're trying to like tease it, but it's an executory interest, which I've already talked to you about. This is why I don't like the order the book discusses it, but you're exactly right. I saw a hand somewhere. Oh, same question? Yeah.
Put the parents back up.
Oh, I'm sorry.
I'm slow.
That's okay. Yeah. Okay. Always, when you start off with a life estate, do what we did last week. Characterize it. Is it a vested remainder or is it a contingent remainder? After you get that, go to the next comma and see, well, is it shifting from someone else or is it springing from someone else? Is it divesting something during life? And that's what subject to divestment means. It's cutting it short during life. Okay, I went with so far. Everyone gets 7 and 8 are probably the hardest examples of this entire topic. I mean, if you get that, you're in good shape. But classifying something as a remainder versus a executor interest is probably one of the harder things you'll have to do for the final. And I want to make sure that you, or at least most of you, grasp that. So any questions on this?
What means cutting short during life?
An executory interest cuts short during life. A remainder floats and waits for someone to die and then determines what's up. The executory interest cuts it short during life. Okay. There actually wasn't much new there. That was more or less what we've covered last week. But with the new wrinkle that when there's an executory interest, right? It's cut short during life. Is everyone okay with that so far? All right, now let's go back to what I was trying to discuss before. There are 2 types of executive interests. Okay? There are 2 types of executory interests. Now, the book notes this, and it's exactly correct. Legally, there's no distinction between these 2, right? Legally, there's no distinction. These are words which are used to make it easier for you to understand. And the first type of executory interest is what's called a springing executory interest. A springing executory interest. And before I define it, I want to give you an example, because I think the example will actually be more helpful than just defining it straight up. So, Madison, let's take a look at this one. It says, O conveys Blackacre to A for life, then to B if B gives A proper funeral. Okay? O convey Blackacre to A for life, and then to B if B gives A proper funeral. So let's read this one comma at a time. So what is A's interest, Madison? Exactly right, okay? We then see following the life estate, okay? Following the life estate, what happens?
So, he is ascertained, or is the remainder given to ascertained? Yes. But it's a subject precedent.
Ah, okay. So you're doing exactly what you were taught to do before this class. You're exactly on the right track. But let's look at what's actually happening here, right? Before you ask yourself these 2 questions, think about this for a moment. A is Madison, so walk with this. A is Blackacre for life, right? What happens the instant A dies? The moment A dies?
But only if
Oh. Does a person have a funeral the instant they're dead? No. Most people have, time that elapses before their funeral. So because we know, Madison, that property must always be owned by someone, there must always be an owner of property, what happens? Oh, and what do we call that? See, this is nothing new. What do we call O's interest? Ah, exactly, right? A has life estate. O has reversion. Madison, why do you know O has reversion? Yes, this is what we discussed a week ago. When you have a life estate and then it goes back to the grantor, it's called reversion. So the moment A dies, it goes back to O. Okay, Rachel. Now what happens if B in fact gives a funeral for A? You know, he makes arrangements, whatever else. B gets fee simple. Yeah. And I'll just make this, and his heir, someone's going to object in a second. B gets fee simple, right? But that's at some point in the future. What do we call his future interest now, right? What do we call an interest that cuts short someone else's estate? Exactly. B has an executory interest. Everyone see why B does not have a remainder. Madison did the exact right thing. She was saying, well, wait a minute, does it follow the death? There's a gap. This is why I love this question. There's a gap. B's interest does not follow a death. Something has to happen first. So what in fact happens is B cuts short O's interest. O will have it for a week or whatever, however long it takes to plan the funeral. But the second B makes the funeral, O's interest cuts short.
Is that the funeral after death? I mean, are there really that many examples of springing?
This is why I love this example. There are not many, right? So if I can ask, Samantha, how would we characterize this executory interest? What's it called? You just said it. Okay. B has a springing executory interest. Okay. What does it mean that springing? The interest of the grantor is cut short. Okay. The interest of the grantor is cut short. O was the grantor. He had reversion. It went back to him. Funeral happened. B cut short O's interest, and B now has in fee simple. B has a springing executory interest in fee simple. Okay. The way you remember springing is if you think of like a brook, like a spring of water, it shoots out from the source. You're basically cutting it out from the source. You're taking the interest of the grantor away. That is what a springing executory interest accomplishes. Your hand was up?
Yeah, I was wondering, so can O, once the reversion occurs prior to the funeral, which is in a week, immediately sell land to someone else? Since they have.
Oh, he can? And what would happen?
So it could be B.
No. O's interest is subject to the executory interest. Whether O sells it, it doesn't matter. Whoever buys it from him is still subject to that same interest. You can't eliminate an executory interest by selling it. Because O has it. At a moment, fee simple subject to an executory interest, right? No matter whom he sells it to, it's pending the funeral. Yeah.
Is there any way O could get B to give up that interest?
Well, O could kill B.
Or, like,
No, I'm serious. The only way that O could actually keep it is if he kills B.
Could he pay B for it?
Of course, right. Always, O can pay off B and say, "Can you please sell me your future interest?" Right? And they can agree to unite the unities, right? They can agree to unite their interests, which becomes fee simple. But short of that, unless O kills B, he's at risk of losing it. He may only have Blackacre for a week. But you have to remember, at any point in time, property must be owned by someone.
Or is this why you see people poisoning each other and people?
Oh my God, yes. Right, because if someone's poisoned, they can't inherit and they can't do various conditions. Yes. Yes, exactly. So the springing executory interest, which Samantha's right, there aren't many examples, but I like this example, it's a good one, come up when the grantor's future interest is cut short, right? And we say that B has a springing executory interest in fee simple. But don't forget O's reversion. All of you forgot that already. Don't forget it. You always have to understand at some point property must be owned by someone. It can't just be floating out there without an owner. And there's a gap between it. And actually, to Samantha's question, there was actually a case once, I read it somewhere, where it wasn't involving a funeral, but what was it? There were these people who were killed on a plane crash and in a mountain. And there was a period of time between they actually died and when they found the bodies. There was actually a gap when there was a future interest unclear what would happen in that period when they had the death and when they actually found the bodies. Right? Yeah.
So, you just want us to say reversion. You don't want us to say fee simple.
Yes, yes. O has reversion and fee simple. Exactly. Oh, one at a time. Yeah, right here.
Would it be the reversion and fee simple subject to executory interest?
Yes. O has reversion, fee simple, subject to executory interest. You can see how this gets very complicated very quickly. I'm trying to keep it easier at the first examples, but you're exactly right. That's our hand.
Same exact.
Yeah. So if you want to be 100% precise, A has a life estate, O is reversion, fee simple, subject to executory interest, and B has a springing executory interest and fee simple. Yeah, I know, right? It's a lot.
If B goes through the funeral, is it automatic? Does it spring forward automatically?
Yes. Yes. It cuts short. Yeah. The second that the funeral is held, it cuts short. Yeah.
You said that for the springing interest, that's really less cost.
No, there's no legal difference. It's simply to help you distinguish one from the next. But I'd like for you to use those phrases.
Okay.
In property discussions, they are referred to differently, even though the rules are exactly the same. Everyone okay with that one? Let's go back to our favorite example 8. Okay, our favorite example 8. We've already discussed that C has an executory interest, right? We already went through this. I don't need to walk through it again. But C's executory interest is not springing. It doesn't cut short O's interest. It's shifting. C has a shifting executory interest. Okay, now right over here. In example 8, right, A has a life estate. B has a vested remainder. Okay, I'll fill in a second. And C has a shifting executory interest. And the reason why is it cuts short B's interest. Okay, it cuts short B's interest. A shifting executory interest cuts short the interest of the transferee, of the third party. The springing cuts short the grantor. The shifting cuts short the transferee. Make sure you're checking whose interest is being cut short. And so if we want to be complete, B has a vested remainder, subject to an executory interest. And C has a shifting executory interest, in fee simple. This is also in fee simple. These get very wordy. And these only have 3 people involved. You can imagine you have questions with 5 and 6 people involved, right? They get complicated. Is your hand up? Everyone get example 8. Yes.
On this one, so we don't have to say like O has nothing.
O has no interest. You can say that, yeah. I mean, this is Pierce's question a minute ago. I'll ask in the exam, does O have an interest? And your answer is no. Or I'll say, I won't ask about O, in which case you don't mention it. But answer whatever I'm asking for.
But every time it should be O will have.
No interest, exactly. And the reason why is more certain than that. When there's a vested remainder, it will never go back to O. The reason why O has no reversion is because it's a vested remainder. It will either go to B or it will go to C. There's not an instant in time in which the property will be ownerless. It will only go to B or C, never go back to O. Questions on, we went on 2 examples and we're 30 minutes into class, right? 45 minutes even. Everyone get 7 and 8 for the hardest examples in the entire topic. Everyone get the difference. you need to be able to distinguish a remainder from an executory interest. The difference is remainders only follow upon a natural death, whereas executory interests cut something short during life. You have to go back and forth. You can't simply say one or the other. You need to read the entire sentence, one comma at a time. Okay. And if I may indulge for a minute, the history of this, of why their executory interests have a lot to do with Henry VIII. Henry VIII was the King of England, and he famously was unable to bear a male son. And under the doctrine of primogeniture, only male son could inherit property. So he went through 6 wives, very famously. Here are the 6. Didn't go so well. So the first wife was Catherine of Aragon, and he sought to get a divorce from the Pope, and the Pope refused to grant it. Aragon was from, I think, from Spain, so there was like, these unions of different countries. The Pope would not give him a divorce. So Henry VIII instead left the Catholic Church and started what became known as the Church of England. So he was able to get himself a divorce. His second wife, Anne Boleyn, also could not give him a male child, so he beheaded her. His third wife, Jane Seymour, she also could not give him a male child, so she just, outlived him. The fourth wife, Anne of Cleves, he divorced her also. I'm sorry, Jane Seymour died. And then the fifth wife, Catherine Howard, she was also beheaded. And then the sixth wife, Catherine Parr, she was widowed. So he had 6 wives, none of which gave him a male son. He didn't know biology at the point because it's actually the male's fault for not donating the correct chromosome for that. So it was actually his fault that not giving a Y chromosome. So, in any event, after splitting from the Catholic Church, I promised at a point, there was a shortage of money. And one of the ways that the king tried to raise revenue was to increase taxes on executory interests. Before this, executory interests weren't really a valid thing. There was a thing called uses, which I won't bore you with, but these were effective ways of cutting things short. The king said, aha, I have an idea. Every single time a future interest is executed, I will tax that, right? I will tax every future interest. Recall the reason why future interests were created was because you had one transaction and it would govern the land at all points in the future. And the king said, no. Every time an interest is cut short, I'm going to tax it. So he actually enacted in 1530, whatever it was, the statute of uses. 1536 or 1535, the statute of uses. And that basically ushered in a way to tax executory interests. But by taxing them, he also made them legitimate aspects of property law. So now executive action, right? Executory interests were a valid thing. So take a look at example 12. I think it's on page, if anyone has a page, just shout it out. 290, thank you, sir. You want to read example number 12, please, Fanny?
After 1536, O Barton was to A and his heirs, but if B returns from Rome, then to B and his heirs.
Okay, stop right there. Okay, so we start, right? What is A's interest? Start reading one comma at a time. Okay, good. So if you just read the first sentence, it says, to A and his heirs, we know A is a fee simple, okay? That's absolutely correct. But Fanny, there's a comma. And it says after that, but if B returns from Rome, then to B and his heirs. Okay? Fanny, is this a fee simple absolute? Okay, I'm glad you said that. That's not exactly right, but you're on the right track. Okay? You saw the but if, right? You saw the but if. And you thought, oh, wait a minute, Blackman said that that's, that's a fee simple subject condition subsequent. Okay. That's not exactly right. The reason why is because of the comma. Okay. There is a fee simple being given. Okay. Fanny, let's talk about this in English. How can A, during his lifetime, lose Blackacre? How can A lose Blackacre during his lifetime? Oh, no. In plain English, how can A lose Blackacre during his lifetime? What must happen? No, read it. What does it say? How can A lose it during his lifetime? Yes, ma'am. If B returns from Rome during A's life, A's interest gets cut short. A's interest gets cut short. It gets executed, right? You know, off with their head. Therefore, B has an executory interest. B has an executory interest. B's interest cuts short A's. So it's not enough to reflexively but if, right? I know you're, that's why the question's there. You need to look at what's actually going on. If an interest is being cut short during life, B has an executory interest. And Fanny, finish it up. What kind of executory interest would this be? Shifting or springing? Why is it shifting? Yes, it's a shifting executory interest, right? So what do we say? We say A has a fee simple subject to an executory interest, and B has a shifting executory interest. Why? This is a key point. B can cut short during A's life. If you ever see an example where something's being cut short during life, it's going to be an executory interest. Now, why is it not, another reason why it's not a fee simple subject to condition subsequent? Karima, we said at the outset of class, okay, that, I'm going to scroll all the way back up. Okay. Karima, when we're dealing with a fee simple subject to a condition subsequent, who has a future interest? Who has a future interest when we're dealing with a fee simple subject to condition subsequent? Exactly. The grantor. Okay. Who has a future interest here? Future interest. And is B the grantor? Okay, it's another reason why you know it can't be the fee simple subject to condition subsequent, right? This is going back to our first class of the topic. The present interest is called the fee simple subject condition subsequent. The future interest is the right of entry. Now that it's confusing, right? The present interest was the fee simple subject condition subsequent, and the future interest is the right of entry. You can't get these confused. Going back to example number 12, it absolutely says but if, but we're talking here about the future interest in a third party, not the present interest. I know that's confusing, but think about it very carefully. We said before that the present interest is the fee simple subject condition subsequent, followed by a right of entry. And who has that right of entry? The grantor. Here, we have a life estate, but that life estate can be cut short by an executory interest. So it's a fee simple subject to an executory interest, followed by a shifting executory interest. Everyone get that? If you don't get it, raise your hand or just ask me. All right, let's try number 13. You want to do it, Jonathan? Read number 13, please. Example.
After 1536, O covenants to stand C for the benefit of A and her heirs. A marries B.
Okay, so we have a situation. So O says, for the benefit of A and her heirs, when A marries B. Okay? So Jonathan, what happens until there's a wedding? Who owns Blackacre? Oh, this is, again, tricky part. Property must be owned by someone at every juncture. So until there's a wedding, O owns it. Okay, Jonathan, now finish it up. what happens when there's a wedding between A and B? What happened to O's interest?
A gets,
O cuts short, I'm sorry, A cuts short O's interest, right? So check this out, right? Let me write this out so you have it in your notes. For example, number 13. You say, O has fee simple, okay, subject to, Jessica, what is the future interest in this case? Yeah. No, future interest for, yeah, what's A's future interest? No. No. What do we call a future interest that cuts short a present estate? Yes, right? A has an executory interest. We say O is a fee simple subject to A's executory interest. O has fee simple subject to A's executory interest. Right? Why? Because A's interest can cut short. And Jessica, what do we call A's interest? What does A have? How do we describe A's executory interest? Oh, don't help your friends out. It's fine, but or at least don't be so obvious about it. Jessica, what happens when A gets married to B?
Shifts to
Don't say shifts. Who is A taking it away from?
from O.
And who is O?
The grantor.
So what do we call it?
Springing.
Springing, exactly. Okay. A has a springing executory interest. Why? Because he's taking it away from the grantor. O. O is the grantor. If you notice, O started off with fee simple. And he chopped up his fee simple, and he gave himself a fee simple subject to A's executory interest. He chopped it up for himself. And then A has a springing executory interest. Once he gets married, it takes away from O, and it comes to him. Does that make sense? You sure?
Yeah.
Everyone get that? Before you label something a remainder, and I know you can be urged to do this, and before you see the words but if, understand what's going on. If an interest is being cut short during life, it's got to be an executory interest. Questions at number 13. All right, let's do number 14. We're doing examples right for the rest of the class, but these are good. You want to read it, please, Serenity? Okay. So again, I want to urge you. You're going to see the word but in there. Okay. Don't leap. Don't jump to say it's a fee simple subject condition subsequent. Even if you see the word but if there, that does not give you what you want. So let's go clause by clause, Trinity, please. So to A and his heirs, right? What's that? Exactly. Don't go against your gut, right? To A and his heirs, fee simple. But there's a comma, and it says, but if A dies without issue surviving him, to B and his heirs. Okay. Now, Serenity, what do we call B's interest here? What do we call B's interest here? Well, Serenity, let me ask you this question. What happens if A dies with children? Does B get anything? Okay. What happens if A dies without kids? Does B get something? Okay. So what is the effect then of B on A's heirs? Right? Oh, it's the topic of today. Let's like this, right? Serenity. To A and his heirs, right? Do A's heirs have a future interest? Well, we don't know who they are, right? Heirs are not calculated until death. But when you have a fee simple, the heirs of A will get something, okay? What happens to those heirs, right? If there are no kids. By the way, heirs and kids are not the same thing. The heirs of A, he may have a sister, may have a brother, right? What happens to the interest of A's cousins and nephews if he dies without kids? What happens to their interest? Gets cut short. And what do we call it when someone cuts short a future interest? Say it louder, you said it. Exactly. Everyone see this. Heirs and kids are not the same thing, right? The heirs of A are like, yes, I get Blackacre when my brother dies, right? I'm his only heir. But if he has no kids, the heirs of A, their interest is cut short. Cut short. So B has an executory interest. B has an executory interest that cuts short A. Now, Serenity, finish it up. What kind of executory interest is it? Well, whose interest is it cutting short? Who's the grantor here? Oh, it's O. It's shifting, right? We say that A has a fee simple subject to an executory interest, and B has a, you just said it, shifting executory interest. Thank you, Serenity. A has a fee simple subject to executory interest, and B has a shifting executory interest. And you know it's shifting because it's cutting short A's interest. It's cutting really the interest of A's heirs, if you want to be precise, but it's cutting short their interest.
Would you say it was synonymous with divesting? I know in past lectures.
Cut short and divesting are the same thing, yeah. Synonyms. Yes, sir.
So if example 14 was altered and saying without issue instead of without heirs,
It wouldn't make a difference.
it wouldn't,
No, no,
it would make it.
no, no. Everyone get number 14. I think. It's number 15. Okay, well, we're gonna run straight through these. It's on the it's at the bottom of the page and it goes to the top. You want to read it for me, please, Bianca? Number 15, right at the bottom of the page.
O conveys to A for life, then to B and his heirs, but if B dies under the age of 21, to C and her heirs. B is age 15. B has a
Okay, stop right there. Okay, sorry, I'll let you read too far. O conveys to A for life, then to B and her heirs. Okay, but if B dies under the age of 21, to C and her heirs. Okay, so let's go easily. So, of course, A is a life estate, okay? What do we call B's interest here? What do we call the interest that follows a life estate? Bianca. What do we call B's interest? No. You're doing exactly what I think I told Fanny not to a minute ago. You're remembering what you learned last week. You see the words but if, and you reflexively think that's a fee simple subject condition subsequent. Remember what the fee simple subject condition subsequent was. That was a present interest. And following that was a right of entry. We're not discussing a present interest here at all. What we're discussing is a future interest after life estate. Bianca, don't be misled. What do we call the future interest after life estate? The interest that follows immediately upon the natural termination of death. What do we call that? Yes, ma'am. B has a remainder. And we ask ourselves two questions, right? What are our two questions? Good. So number one, is B ascertained? Yes, ma'am. What's our second question? Okay, good. And this is where it gets tricky. And this is where the commas help you. It says, then to be in her heirs, comma. We stop at the commas. I know it sounds dumb, but it works. Is there any condition precedent, Bianca, this part right here? To be in his heirs, is there any condition precedent? No. So what kind of remainder is it? Yes, exactly. B has a vested remainder. B has a vested remainder. Everyone see that? But we don't stop there. Go back up to Adam. We then read to the next clause. Okay? What does this stuff afterwards? But if B dies at the age of 21 to C in her heirs, right? What is the effect of that clause? It would cut off B's heirs, right? B's already dead, right? But it cuts off the interest of B's heirs. And what do we call something that cuts short an interest? So it's a vested remainder? Finish the sentence. Yes. B has a vested remainder subject to an executory interest. B has an executory. B has a vested remainder subject to an executory interest. Everyone see that? You need to walk through each of the steps that I just walked through with Bianca a minute ago and continue with Adam. Yes, sir.
Would you go as far to say, like, identifying C's interest specifically? So
I'm going to ask that next.
C has a shifting executory.
You just spared Thomas a question, but yeah, that was my next question. My next question was, what is C's interest? And you would say that C has a shifting executory interest. Way to steal his thunder, right? C has a shifting executory interest. Right? So A is life estate, B has a vested remainder subject to an executory interest, and C has a shifting executory interest. Yes, ma'am.
In the book, when they say executory limitation,
Same thing.
it's the same thing.
I like executory interest better. I don't know why. I prefer that, but
It's fine. I just use so many synonyms.
I try to only say executory interest. I try not to use more words I need to.
Okay.
I like executory interest better. Limitation makes you think of like limits. Anyway, I like interest better. Everyone see that? Number 15. Okay. Everyone with me. For number 16. Keep rolling through. These examples are very, very helpful. All right, Thomas, you were spared the question, but you'll get the next one. All right, please read the number 16.
O conveys to Hartford School Board, but if the premises are not used for school purposes greater than 20 years, to town library.
Okay, so this one's actually trickier, right? They get progressively harder. So it says, O conveys to the school board, but if the premises are not used for the school purposes in the next 20 years, to the town library. Okay. So, what was your first instinct when you read this? What was your first instinct when you read this?
That there's
Okay. And I suspect virtually everyone in this room said, oh, wait a minute. That's a fee simple subject condition subsequent, right? You said, but if fee simple subject, that's right. So you all thought. But you have to look at who's getting the who's getting the future interest. I always do this. I think two words out of what I'm saying. In every example of the fee simple subject condition subsequent, Thomas, what's the future interest called?
what was that?
The future interest following a fee simple subject condition subsequent. What's a future interest called?
It's called a right of it.
Yes, sir. And in every case, who had the right of entry? In every case that we did. Bingo. The grantor. In every case we did, a fee simple subject condition subsequent was followed by a right of entry in the grantor. However, here, that's not what we have. We have a fee simple followed by a future interest in someone else, right? In the library. So it's not going back. There's no right of entry in the grantor. Instead, what's actually happening is a third party, the library, is cutting short the school's interest. And Thomas, what do we call something that cuts short an interest? Yes, sir. So this is not a fee simple subject to an addition subsequent. It's a fee simple subject to an executory interest. Oh, you never thought about that, right? It wasn't fee simple subject to condition subsequent. It was like this massive block. These are different words. It was a fee simple that was subject to a condition subsequent. Here we have the school board has a fee simple subject to a executory interest. And we say this, the library then has a shifting executory interest. Everyone see that? This entire subject to business, this is simply descriptive. You can have a fee simple that's subject to condition subsequent, or you can have a fee simple subject to executory interest. And then you know, after this executory interest, the future interest is called a shifting executory interest. Right? So do not be led astray by seeing the words but if. I promise you that you'll do this in the exam. Don't do it. Look at what's actually going on. This is not like what we did last week. Yeah.
So that means the right of entry is always the grantor.
Yes, you only use the phrase right of entry when it's in the grantor. Exactly. Okay. All right, now I'm going to mess with you more. Let's do number 17. 17 is even harder. Okay. What was I up to? Nancy, read number 17, just the grant, please. Okay. So this one, and the answer is in the next sentence. I'm not giving anything away. Nancy, when you see the word so long as, what does that make you think of? I'm sorry? Yeah, you said it. Yeah. So what actually we have here is the school board has a fee simple determinable followed by an executory interest. Okay. The reason why the other one before that is a fee simple subject executory interest, and this one is a fee simple determinable. Let me write this out. What we have here, oh, it's right here, is a fee simple determinable subject to an executory interest. For the rules that I can't even explain to you, you're allowed to have a fee simple determinable subject to an executory interest. But the one before it is not a fee simple condition to a subsequent subject to an executory interest. Yeah. Watch this. In 16, I simply said it was a fee simple subject to executory interest. Okay. For reasons that you simply have to accept and don't challenge me on. This is a fee simple determinable subject to executory interest. For whatever reason, due to the vagaries of history, you can have an executory interest following a fee simple determinable. Okay. But you're not going to have the fee simple determinable. The reason why, and this is somewhat obscure though, is with determinable estates, you can actually have the interest going to a third party, right? But the future interest is not a possibly reverter. This is the tricky part. Usually after a fee simple determinable, you memorize that the future interest is a possibility reverter. But here, because it's going to a third party, the library, future interest that's cutting short is an executory interest. After class, I'll get you in a second. After class, go back and do 7 and 8 and 17, 18. These are probably the two hardest pairings in the entire discussion. These are things you have to just memorize. There's not a lot I can help you with, but 7 and 8 and 17, 18, they're even numerically parallel. Yeah, Cody.
I don't really understand how it's subject to an executory interest, because if it's a fee simple determinable, it automatically cuts short. So if it automatically cuts short, there's nothing to cut short. I mean,
Yes, but where's it going to?
To a third party.
And that's why it can't be a possibly reverter.
So they just.
You see. Yeah, no, Cody's question actually stated the issue quite well. The fee simple determinable cuts short the estate automatically, and it's got to go somewhere. But since it's going to a third party, they will not call it a possibly reverter. They call it an executory interest. Whereas, I'll get you a second, Adam. Whereas with number 16, it's not automatic, so then they have to call it the executory interest to make it automatic. The right of entry is not automatic, but here in number 16, it becomes automatic. Yeah.
Is there any significance to the fact that there's a time window in 16, like next 20 years, as opposed to 17?
Not really. No. Yeah, let me see. And I think I said 17, 18. I meant 16, 17. My apologies. In 16, right? It's executed immediately. And you may recall that the fee simple subject condition subsequent is not automatic. In number 17, it's a fee simple determinable. Those are automatic, and therefore you have to match it with something that's automatic, which is the executory interest, but it can't be a possibly reverter because that goes back to the grantor. These two examples, just accept. They're not pretty, but just accept them.
Are the words followed by?
Want to raise your hand first? Yeah. Yeah.
I have
Yes, sir.
the words followed by.
Followed by or subject to, it's the same thing. I like subject to, but you can say followed by. You'll see them these phrased in many different ways, but try and do what I say, and then I'll know what you're talking about. I'll know other things too, but try and follow how I explain it. Everyone with me so far? This is probably the toughest topic of the entire class. If you get this, you're coasting from down here. Yes, sir.
I don't remember what you mean by automatic.
You'll recall the right of entry, right? What the right of entry means is you have to go to court and get an order to say that you own it. Whereas with the fee simple determinable, the second the condition is broke, the second the thing is no longer used for school purposes, it transfers automatically. Remember that? Let's try on page 292. There are a series of questions. And also, I'm not going to have time to get to them as well. But on page 292 at the bottom, there are these review problems. The answers are in the book. I encourage you on your own free time, I know you have plenty of it, to go through those. But let's at least try in our remaining 12 minutes to go through at least a few of these problems. Lola, please. Just start reading number 1.
Owner of Wiseacre comes to you to draft an instrument of gift. O tells you he wants to convey Wiseacre to his son A for life, and upon A's death, O wants Wiseacre to go to A's children if any are alive, or if none are alive, then alive to O's daughter B. Consider the following conveyances, all carrying out this intent, but each creating different future interests.
Okay. So keep reading letter A, please.
O conveys to A for life, then to A's children and their heirs. But if at A's death he is not survived by any children, then to B and her heirs.
Okay. So let's look at this one very carefully, Lola. So it says to A for life, then to A's children and their heirs. But if at A's death he is not survived by any children, then to B and their heirs. So let's look one at a time. So we know that A has a life estate. What do we call the future interest following the life estate, generally speaking? In a third party, what do we call that? Yes, ma'am. So we know that A's children and their heirs have remainder. Okay, so we ask ourselves 2 questions. What kind of remainder are we talking about here? Are the children ascertained at this point? How do we know that? Yeah, there are no kids, right? There are no children, therefore the children cannot be ascertained. Exactly right. Okay. So what kind of remainder is this, Lola?
Um,
If the parties are not, yes, ma'am, thank you. It's a contingent remainder. It's a contingent remainder. Everyone see that? Nothing hard. Okay. But then we get to the next sentence. It says, but if at A's death, he has not survived any children, then to B and their heirs. Okay. Now, I mentioned these pairings before. So Camille, when you have one contingent remainder, what is it always going to be followed by in almost every case? Yes. So we know at this point, right, that B has a contingent remainder. Okay. B has a contingent remainder. Now, Camille, here comes the harder part, though. What happens if there are no children of A? Okay. And B dies without any heirs. Yes. What does O have? What do we call O's interest here? Okay. Wait a minute. Did I do that wrong? Yes. O has reversion. O's reversion fee simple. That's right. So we have here a life estate followed by contingent remainder in A, children, followed by contingent remainder in B, with O with reversion. All right, with me. The next, yes.
So A's children have a contingent remainder?
Yes, I mean, they're not born yet, but the class, right? The class of people would have the contingent remainder. Yeah.
So we only say that it's a vested remainder when there's somebody already born.
It could even be in utero, but yes.
Okay.
Yes, but there's an ascertained person in existence. The next paragraph says, 2 years later, twins are born, C and D are born to A. Okay, what does this say of the title? Samantha, if you have twins, right? A still has a life estate. How do we characterize C and D's interest?
now they have a vested remainder.
Okay, C and D have vested remainder. Why is it vested?
Because now they're ascertained.
Yes, but is the class closed? Can there be more kids?
Class closes upon death. A.
That's right. So what do we call their vested remainder?
Subject to open.
Exactly. C and D then have vested remainder subject to open because they may get new brothers and sisters. So now, Norma, let's move that way. We know that the first future interest is a vested remainder. What comes after the vested remainder? Think of our pairings. Yes. And how do we know this is an executory interest? What happens to potentially C and D's interest? Right. Think about it this way, right? C and D are alive today. They may die tomorrow, right? As long as C and D are alive, their heirs have a future interest. That's their money ticket, right? But the second C and D die in a horrible train wreck, whatever it is, their kids are cut off. And because you're cutting off a future interest, B has an executory interest. And Norma, what kind of executory interest is it? Yes, ma'am. It's a shifting executory interest. Okay? It's a shifting executory interest. Okay? Jill?
Does D have?
Well, C and D have the same. They both have a vested remainder subject to open.
But only one by itself.
I said they both died in a horrible train wreck. Right? And if one of them dies, still has a vested remainder subject to open. I think that's actually the next paragraph, right? That was your question. If only one of them dies, right? So suppose that C dies during A's lifetime and that A is survived by B and D. What happens, right? Okay. C's share, right, is not divested at C's death. It's only divested if A dies first. So D survives A, and then basically D takes everything because they're still a living child. Okay. Adam.
I just want to make sure. So you're saying that when the twins are born, their interest turns into a vested remainder subject to open?
Yes.
Which switches B's interest to a shifting executory interest?
Yes.
What is that interest cutting off? That's kind of where I'm getting.
Well, previously, B had a contingent remainder, right? In the first paragraph, B had a contingent remainder. The second the two kids are born, B's contingent remainder transforms into a shifting executory interest. Think about that for a second, right? During life, your interest can change depending on what happens, right? Because as soon as those kids are born, you have a vested remainder. And a vested remainder must be followed by an executory interest. Think of the pairings, right? You start off with two contingent remainders. Once the first one becomes a vested remainder, it then must be then followed by an executory interest, which is shifting.
But as far as the terms of the grant are concerned, it says, what if that A step is not survived by children? What effect?
You need to judge it based on the facts on the ground. You need to say here, there's no children. But the second the children are born, it actually modifies how we interpret the document. The words of the document remain the same, right? The document's not changing, but we interpret the document differently based on whether their children are alive or not.
So it's changing to a shifting executory interest, but when A dies with children, does that executory interest just get dispelled?
When A dies with children, the executory interest never executes, right? It never goes into effect. An executory interest does not need to cut short. It could. There's the possibility, the chance that it cuts short, but not a guarantee. Cody.
You told us that we determine whether or not a remainder is vested or contingent whenever the document is drafted.
You also have to look at the facts on the ground.
So it can change from a contingent to a vested.
Yes.
Okay.
You need to look at the facts as they are. And you will, I mean, if you look at my old exams, people are born, people die in train wrecks. I mean, things move. And at any given point, the document itself is not changing. The document is fixed in writing. But how we interpret it evolves based on who's alive and who's dead. Questions? Do yourself a favor. Do the review problems on page 292. The answers are on page 1296. Walk through them, and if you have any questions, you can ask me. But this is a very tricky topic, probably the trickiest topic of the entire semester. And if you get these, you will be in pretty good shape. Any questions? Okay, I will see you in class next time. Thank you.
Had a couple questions.
Yes, sir.
When we're doing number 7, it was O to A for life and B to heirs, and B survived A, and if B doesn't survive A, then C to heirs.